Welcome everyone to lecture number 28.10. So we have discussed till article number 20. Now we are going to discuss about article number 21. Okay, what exactly is this article 21? So article 21 of the Constitution provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Okay, what exactly this procedure established by law, due process of law, we'll see in this lecture. So article 21 deals with the protection of life and personal liberty and personal liberty. Okay, so within this article 21 we'll see what exactly is this right to life. Okay, we'll try to understand this right to life. Right to life. So yeah, so no person shall be deprived of his life or personal liberty except according to the procedure established by law. No. So when we have right to life, so it doesn't mean that we have right to take someone life also, as we have seen in that freedom of speech and expression. In that, if we have a right to freedom or sorry, right to speech, then it also means that we have a right to be a silence. Okay, the same case will not be applied here. So no person shall be no person shall be deprived of his no person shall be deprived of his life or personal liberty except according to the procedure established by law. Procedure established by law. What does it mean? That we are telling that no person shall be deprived of his life or personal liberty. Now when we are telling that no person, so what does it mean? That prisoner or the person who are sentenced to um, capital punishment, are they also counted under this? No, there is an exception. This right to life is not a absolute right. Yes, the no person shall be deprived of his life or personal liberty, but there is an exception, that it should be according to the procedure established by law. If a court has given a punishment to a person to be a jail for a life imprisonment or a 10 years jail, so yes, his personal liberty will be there, but it should be by the procedure established by law only. If a person has been given capital punishment, so yes, his life will be taken away as per the procedure established by law. So yes, there is exception, but apart from that, no person should be deprived of his life or personal liberty. To understand it, we'll see in more depth. I think I have give you pretty much explanation for that, but we'll dig more deep under it. So Samtha versus state of Andhra. In this case, the the verdict came, that conclusion was made, that life is not merely the physical act of breathing. Okay, there are multiple meanings of the life that should also be considered. It doesn't mean that let us suppose a girl has been locked by his parent within her house. Okay, so now it doesn't mean that right to life is not violated in that case. Yes, right to life doesn't mean that you are breathing, so yes, you are alive, so right to life is there. No, there is much more sense for this right to life. Okay, so this was derived from the Samta versus state of Andhra. In this case, this meaning of life was more derived. What was that? We'll see. So it tells that under this case it was concluded that life is not merely the physical act of breathing. Okay, it doesn't mean if you are breathing, so yes, life your right to life is not violated. There is something, life is something more, life is something more. Okay, what is that? We'll see. So we have, as I have discussed you, inferred rights. Okay, what do you mean by statutory rights are there, constitutional rights are there. Now there is something called inferred rights. Inferred rights are rights that are deals with the dignity of the person. As per the law, it deals with the dignity of the person that has been derived from the existing laws. Okay, so what kind of inferred rights are given, are being derived from this right to life? So it counted under the inferred rights. What is that? We'll see. See, first it tells right to live with human dignity. It tells that right to live with human dignity. So if some person is living on the roadside and he is unable to take a food, he used to pick a food from the garbage and all, he used to eat that thing. Yes, the person dignity has been dropped, has been challenged, has been affected, and here the right to life is not being followed. Okay, these things can be challenged, and yet these things happen in real society. So yes, if there is a scenario where a person is unable to live with a dignity, so right to life is violated. Okay, now what can other things will be said? Right to right to decent environment. Right to decent environment. We have a right to live in a clean environment. So let us suppose you are living in an environment where the pollution is happening. So yes, your life right to life is being snatched. Okay, is affected. And in that scenario there are many cases. Let us suppose if you are from a poor background, poor people, and there is a rich people, it is the rich people who pollutes the more. Okay, they pollute the more environment. They have a car, they have a bike. These poor people don't have such amenities. Okay, and because of that ultimately these poor people are affected. Ultimately these right of life of poor people are being snatched. Okay, so this is another cost. Whenever there is cost is being calculated, the cost to environment is also calculated. In that case poor people are always being affected. So yes, one is that right to have a decent environment. We have a right to live in a decent environment. So that's why whenever that's why in a residential area, uh, at nowhere the uh, industries are being set up because the permissions are not given, but yet we see sometimes the industries are there. So it's because of the some nexus between the the political parties and the businessman. Okay, so that is there, but you can challenge those things if that kind of industry is present within the residence, because you have a right to have, because you have a right to have a decent environment and have a right to livelihood. Okay, right to decent environment and right to livelihood will also be there. You have a right to shelter. If any person who is reading who sits beside or live behind the beside the side of the road, yes, their right to life is being snatched. And yes, these things are happening within the country, but we are ignoring it. And many a times the verdict has been given by the courts also that government have to take care for such people, but because they are poverty, they are poor, they don't know their rights, they are not being helped and they are shelterless. So yes, right to shelter will also be counted under the right to life. These all are things are inferred rights that has been concluded from the article 21. Okay, we have a right to privacy. We have a right to privacy. We have a right to health. Okay, we have a right to fair and speedy trial. Okay, but we have seen in the court the case used to run for more than 15-20 years, and when the verdict comes, the person itself has been died, or um, or the person have become so old that he can't use the money, or being whatever the things the court has given the verdict, he is unable to enjoy those things if the court has given a verdict in the favor of that person. Okay, so the person have a right to be a fair and speedy trial. Similarly, the person have a right to travel abroad. These all are inferred rights that has been extracted from the existing right. We have a right to we have a right against solitary confinement. We so see what is happening, that there are uh, multiple rights are being derived for that. And yes, these things can be challenged within the court if something is being taken away from you. Okay, so yes, if you are being taken under the imprisonment, um, in a single cell, with no contact to the people. Okay, if you are being imprisoned in such environment where you can't talk with anyone and all, yes, so you have a right against that solitary confinement. Understood? And like that there are many more. There are many more. Okay, understood? So yes, so what exactly is the significance of article 21? We have seen what are the things that is present under the article 21. Now we'll see the significance of it. What is the significance of article 21? Significance of article 21: it helps to enjoy all the fundamental rights without any exception. This is the power of the article 21. It Because we have a right to live. So in the right to live, we have a right to get freedom, we have a right to have my privacy, we have a right to take a health. Okay, if I am unable to afford a health, then then this is a role of the government that they have to provide a proper health facilities to me. Okay, I have a right to health as per the it is given by the Indian constitution to me. Okay, so yes, this article helps to enjoy all the fundamental rights without exception. Without exception, it makes it makes a distinction. It makes a distinction between a constitutional and a police state. Okay, it is also called as a, it is this article 21 is also called as a backbone of article part 3 and part 4. Backbone of constitution, whatever the things is present under the part 3 and part 4. Why, what is happening, why it is giving so much important? Part 3 is related to the fundamental rights and part 4 is related to DPSP. Now what is happening, like whatever the laws is being made by the government, they are being taken care with the DPSP. And what DPSP things are telling, that we have to give a reservation to the tribal people, we have to give a reservation to the ST people, to the economical backward sections and all. So what is happening behind that, the main role behind is that they just want to live, they just want to make such people to live within the society with more dignity, with respect, with ease and all. So what are this thing is concluding, this thing have a conclusion of this article 21 only. Article 21 is the right to live, and within this article 21 we have seen that there are enormous amount of inferred rights. Whatever the things you can think for required for the leave, like if I tell that I have a right to eat, yes, this will be also included under this article 21. I have a right to roam on the street, roam in the garden, yes, this will also be inferred under the article 21. So this article 21 is so vast, it captures so things, so that's why it is called as a backbone of the part 3 and part 4. Okay, now there are some exceptions for it. What exactly this exception, we'll see. Yeah, exception. Now for this exception there are 3 tests that has to be checked. Like within the exception it is called as a procedure. This is the exception, procedure established by law. Now if you have done, let us suppose you have done a crime, so yes, as per the law you will be imprisoned. Your right to roam outside the street, right to move within the country, all the rights will be snatched. Okay, yes, you will be given right to eat, right to take breathe, you right to have a conversation with other people, so that kind of right will be there. But yes, that kind of right will be also snatched if you have done something more heinous crime kind of things, and if that um, if you have been awarded with a capital punishment. Okay, so in that case, yes, your right to eat, right to live, your ultimately it is that your life will be snatched. Okay, so yes, all the things is valid only when the procedure established by law is there within the country. So now there is a 3 steps, 3 tests that has to be performed with the procedure established by law. For the procedure established by law, whether whatever the things is being done is under the procedure established by law or not, there are 3 tests for that. Okay, what is that first test? Firstly, there must be a law justifying interference with the persons life or personal liberty. Okay, so first thing is that if anything is happening against you, if there is law, so first it will be checked, is there any law or not. If you have done anything, let us suppose you have killed someone, so you have killed someone, this is a good thing or bad thing, when it will be concluded. So first there will be checked, is there any law that tells that killing someone is prohibited as per the Indian law. Is there anything written in the constitution? Yes, it is written. So there must be a law justifying interference with the person's life or personal liberty. Okay, now another aspect. Secondly, the law should be a valid law. The law should be a valid law. Okay, so now the question will be there, whatever the law that we have, is that law valid or not? If it is not valid, if it is going against the fundamental rights of the people or anything, if it is against the basic meaning of the constitution, okay, so then the law will not become null and void, and this power is given to the Supreme Court. Okay, so now whenever the such things happen inside, goes in front of the Supreme Court goes with these three tests. So first Supreme Court will check whether this law is there or not. Yes, the law is there. Then Supreme Court will check whether this law is justified or not, whether this law is valid or not. Okay, after that only then Supreme Court will, if the law is valid, that if yes, this is a law, it is a valid, that yes, it is passed by the legislature and all, and yes, this law is not being contradicted with another law. So now the first test is passed, second test is passed. Now the third test, important test. The third test will be that, thirdly, the procedure laid down by the law should have been strictly followed. Okay, so is there a procedure and is it followed or not? On that basis, this procedure established by law will be there. Okay, so no procedure established by law can only protect an individual from an arbitrary action of an executive, not legislature. So what is telling, the procedure laid down by the law should have been strictly followed. So it means that, so that law should be, is there law, is this law is not arbitrary. So let us suppose any arbitrary action has been taken by the police. Let us suppose police has just taken you, snatched you, and took into the prison. Okay, so it will be checked whether this law is there or not, whether whatever the, let us suppose a person A has been arrested by the police. Okay, now the court will see whether there is a law or not for which the person A is arrested. Now there will be check whether this law is valid or not, and after that, that will check whether the procedure laid down by the law should have been, whatever the procedure has been given, that let us suppose when a person is arrested, it has to be followed with, it has to be taken in front of the court within 24 hours. And let us suppose the person has been taken arrested and from last 48 hours. So now this court will check whether the law, whatever the law is there, is strictly followed or not. Okay, procedure is test. This whole test will tell that if this everything is followed. Let us suppose if the person A has been taken in front of the court within 24 hours, next day if it is presented within the court, so then court will say that yes, all the three tests are passed, and yes, the procedure established by law has been followed. Okay, and if yes, if the person is taken in more than 48 hours, and that's why this the person has not been led in front of the court, so in that case the court can give a bail also. For that there is a case to case basis. So in that, procedure established by law has not been followed. Okay, so yes, so this was the three tests. So if that above three conditions are satisfied, the court will not go behind the intention of the legislatures and uphold the deprivation of the life or liberty of an individual, even if the law is unreasonable or unjust. Even if a law is not just true, like if law is very vague, it's not making any sense. In that case also, these three tests has to be passed. If these three tests is passed, court will give his judgment on the basis of it. Okay, we'll see there are many twists on that. So this law has to be this thing step has to be followed. Even the law is injustice, if this test is passed, the person will be convicted under that crime. Okay, so now there is a protection against the executive alone. So this is only providing you the protection with the executive. It is telling about the arbitrary action taken by the executive. In that case, this will help you. But if the law is being prepared by the legislature, if the law itself is vague, then this thing is not going to help you. Are you getting my point or not? Whatever the three tests that I told you, procedure established by law, this is going to save you from the arbitrary action of the executive. Okay, this is not going to save you from the arbitrary action of the legislative. Okay, so this is called as a, this is something called as a procedure established by law. Okay, now in America there is something called as a due process by law. What is that? We'll see. It is followed in USA. In the USA, it protects an individual not only from the arbitrary action of the executive, but also from the arbitrary action of the legislative. So let us suppose, yes, the person must be, yes, is there any law? Let us go back to this three test. In USA, what will happen? The court will go and check, is there any law for what this person has been arrested? Yes, the law is there. Test 1 passed. Now for the test 2, the court will go, is there, whatever the law is there, is that law is justice or not? Is it sound, sensible or not? Okay, let us suppose a scenario, whatever the law legislature has passed, the court sounds that this law is completely unreasonable, unethical, this is not making any sense. Then in the second step only, the court has the power to strike down, and it will tell that the second test of this thing, it has been failed. The law, whatever it was there, it is not making any sense, it is not as per the constitution. So this so the due process of law has been not followed, so the person cannot be arrested and it will be freed down. Okay, and now the procedure laid by the court, here the it isn't followed or not, it is as per the constitution. So here the law validity will also be checked within the USA. Okay, so in USA, the law, court protects an individual not only from the arbitrary action of the executive, but also from the arbitrary action of the legislative who forms the law. So in USA, right to life can be snatched. The court will go behind the intention of the legislature. If the law is unreasonable, judiciary can give the decision not to snatch the right to life. Okay, judiciary has the power for that. So now we'll see that in the Lawrence versus Texas case in 2003, I will give very one example for that. In Lawrence versus Texas case 2003 of the USA, what happened? Anal sex between two individual is crime. That was a law. Okay, that was their law. Okay, within the same gender, it was for the same gender. Okay, so anal sex between the two individual is crime within the same gender. So what was happened? Sodomy law has happened. So when it went to the Supreme Court of USA. Supreme Court of USA said that first it will go, is this the law? One extra step will be added in the whatever we have a procedure established by law. There will be four steps. There will be four steps in due process of law. What are the first steps? We'll see. Is this a law? Yes, this is a law. You can't have an anal sex. Yes, this is a law. Second, so yes, test is passed. You can't do an anal sex. If you have done so, there will be you will be charged under it. Okay. Now, second, is this law valid? Yes, law is valid. Law is there and it has been passed by the legislature and all. Yes, law is valid. Law has been validated by the legislature. It is passed. So yes, law is valid. Third, is the procedure followed? Yes, procedure is followed. Whatever the methods and process was there, police has followed it, and on that basis only the person has been arrested, and police has followed all the steps, all the measures that they have to take. They have taken it. So yes, procedure is also followed. Okay, so this whole thing is the same as per the whatever the things that is present under the procedure established by law. Now there is a fourth step, that is a very important one. Now there is a fourth step. What is that? Now court have a right now, but this law is inherently bad. But whatever this law, but this law is inherently bad. It violates the right to privacy. It violates the right to. Two person is there within the room. What they are doing, it is not the business of a state. Okay, what they are doing within their room, within their house, it is not a business of the state. Okay, so this is violating. It is against the right to privacy. It violates right to privacy. Thus, therefore, this law must go invalid. Okay, this law must go invalid. So this is within the USA. It is followed due process by law. In the USA, it is followed due process of law, where court can also check whether this law is not violating any right or not, right to life and all, whether this is being violated or not. So that can also check, and this law was then struck down and it was become unconstitutional. Okay, if the same case happened within the India, Supreme Court will check the first thing, second thing and third thing. We'll see, don't take this conclusion. We'll in the next in the coming just moving forward with the lecture, you will see a twist in this. Okay, so Supreme Court, as per the Supreme Court, we are following procedure established by law. So this thing will be court will not see. On the basis of it, court will give the verdict and person will be persecuted as per the whatever the law said. Okay, now this was the story of India. Now India moved from the procedure established by law to the due process of law. How the India moved toward it. Okay, so see, whatever we have seen procedure established by law, it is for the India. This is for the India. Due process by law, this is followed in USA. In the USA, court has power to check whether the law, whatever is there, they have the power to make a null and void, to check whether whatever the law is there, it should not affect the person dignity and all. So all these things are being checked. Okay, this thing is not being present within the India procedure established by law. Now we'll see that how this is going to be changed. Okay, so India will move from procedure established to due process. How we'll see. Okay, how we'll see. In the A.K. Gopalan, in the A.K. Gopalan versus a state of Madras, or the state of Madras in 1950. A case went. Supreme Court said that we followed procedure established by law. Supreme Court said we followed procedure established by law. Okay. Now we'll see another scenario. In ADM Jabalpur versus Shivkant Shukla, 1976, the emergency era. This was our emergency era. Okay. Supreme Court again said we follow procedure established by law. Okay. Now we'll move ahead again. But now the twist will come. But in Menaka Gandhi versus Union of India, when 1978, after 2 years of that only, Supreme Court changed the meaning. Supreme Court changed the meaning and said we follow the due process of law. So now from India, 1978, through the Menaka Gandhi versus Union of India, Indian Constitution started to follow due process of law, not procedure established by law. So now the fourth test has to be followed to check whether if the person is convicted under any crime. So court will check 4 steps. First, whether in whatever the scenario the person has been arrested, or whatever the charge has been taken against the person, or whatever the things happen with the person, it will be checked whether there is a law for that or not. Okay, if there is a law, then they will move to the second step, whether this law is valid or not. It means that whether this law has been passed by the parliament and it is currently exist or not. In the current scenario, they will check the validity of the law. If the law is valid, it is passed by the parliament and all, then the court will move to the another third step, whether the procedure is followed or not. It means like whatever the procedure has been mentioned within the law, whether it has been followed by the police authorities or not, that will be checked. Now the last step, where this law will also be checked, whether this law is not what kind of law is that, whether this law is against the human right violation or not, whether this law is against the humanity or not, that thing will also be checked by the court. And yes, from the Menaka Gandhi versus Union of India, from the 1978 Supreme Court changed the meaning and they started to follow the due process of law. So now from this scenario, law has to be, from here, law has to be reasonable. It should not be anything. Okay, it must have to be a reasonable. Law has to be reasonable, which is an essence of equality under Article 14. The procedure must be right, just and fair. Whatever the procedure has been mentioned, it should be right, just and fair. Whatever the procedure is there, the procedure should not be that police has to bring the person within the court within the 4 hours of that. This is not possible, man. How is it possible? Yes, certain time period should be given, so there should be fair procedure should be there, right should be there, justice should be there. So all those things, procedure must be right, just and fair. Procedure must confer to the principle of natural justice. So it is telling that procedures must conform to principle of natural justice. Okay, not political justice, natural justice. It means that, what does it mean? We'll see what this natural justice mean. We'll see. Nobody shall be sentenced without being heard. You have a right to be heard. The court must hear you. So nobody, without a hearing, you can't be punished. So nobody shall be sentenced without being heard. Okay. Second, no person shall be the judge of his or her own case. So let us suppose, is there any case filed against the judge of the court, so he can't be a judge of his own issue. Okay, so no person shall be the judge of his or her own case. So it is a natural justice. The authority shall act bona fide. The authority shall act bona fide. Bona fide means like in the good faith. Good faith should be there within the authority who is handling those things. Okay, so central inland versus there is one more case. So where this natural justice is present within the article, where this natural justice is present within the article. So in the central inland water transport corporation versus corporation limited versus Bojo Nath Ganguly case that happened in 1984. What happened in this case? Supreme Court said, in the Supreme Court said that principle of natural justice are found in where? Are found in Article 14 of the Constitution. Through the Article 14, this principle of natural justice is given. Okay, so it has been derived. Now court has come up and said that what this natural justice also becomes under the fundamental right. From where this natural justice comes? What Article 14 tells? Article 14 that equality before law, everyone is equal before the law. So yes, this is natural justice. We can't consider someone already a criminal and then we'll start a case on that. No, everyone is equal before the law, and until and unless someone is not proved guilty, till that person the person is not guilty. Okay, so yes, so it is an essence of the Article 14, this natural justice present under the Article 14, and it has been derived from the Article 14. This natural, it has been inferred from the Article 14. Okay, so let me, okay, so proceeding ahead. So as we have discussed that right to live, so if there is a right to live, do we have a right to die? So we'll discuss what is the constitutional legal verdict on that. So in Rathinam versus Union of India, in Rathinam versus Union of India case that happened in 1994. Okay, there was a judgment regarding this right to die. Supreme Court said that in this case, in this Rathinam versus Union of India, Supreme Court said that as you have a right to life, then you also have right to die. Okay, so Supreme Court legalized that yes, it is your life, so death will be your also it is up to your hand only. So due to this thing, suicide become legalized. Suicide got legalized. Okay. So after that the Supreme Court deleted the section 309 IPC, as this section is criminalizing the suicidal act. But this thing was quickly overturned. This judgment was quickly overturned, because this judgment was completely against humanity, where you are now you are legalizing the suicide. You are telling that, you are promoting the person that yes, you can do suicide because it is also legal. Suicide is nowhere legalized. You only have a right to life, you don't have a right to die. Okay. So this was quickly overturned. This was quickly overturned. Through which judgment we'll see in Giancor versus State of Punjab in 1996. Okay. The earlier judgment where the right to die was legalized, it was in year 1994. Soon after 2 years, Supreme Court said Supreme Court said that yes, you have right to life, but you do not have right to die. So right to die is a criminal offense. So if you are doing a suicide, there is a case behind that. Case will be charged against you, and there are some procedures and all that will be taken against that act. Okay. Yes. Humanitarian ground is also taken care, that why that person is being want to take his or her own life, what is the reason behind that. So that thing will morality will also be there. But yes, at any case, this right to suicide or right to die is not legalized. It is completely against the fundamental right of a person. It is completely criminal offense. So government recently said, Union of Cabinet passed resolution that section 309 IPC should be deleted. That should be deleted, as if you commit suicide, no punishment will be there for you. So if you survived, then government or court or law will help you. He should be supported, but still it has not been deleted. So government came up in front of that, if a person is doing a suicide, there must be some reason behind that, right? There must be reason behind that. We have to help that person, like why, what exactly happened that the person want to take his or her own life. Okay. So currently there is a punishment under the 309 IPC, where the suicide is a criminal offense. So government has requested that we should delete 309 IPC from the constitution, but yet it is not deleted. Okay, 1 second, let me. So yet this 309 IPC is not deleted and it is still a offense. So a very important case was there, Arun Shanban case. And this came in the news also, where one lady was in the coma, where she was brutally raped by the peon, or she was a nurse in the hospital, and by the peon of the hospital, where she was brutally raped and went into a permanent that lady went into a permanent vegetative state. Okay. Where whole life she was in coma. Matter went to the court. So when, see what happened, she was brutally raped when she was young, and she died become as old. I don't remember exact year for that, but I'm telling you that just remember that she was very young and she died as a old lady, literally old lady. So you can think a number of years more than, I guess, 35 30 or 35 years like that. I don't exactly remember the years for that. You can google it. So for that number of years she was in coma state. Just think, she was completely unconscious. Her her only body movement, evolvement, heart, and all the internal organs were working, but she didn't have any conscious. Okay. So now when she actually died, this matter went to the court for the mercy killing of an individual through euthanasia. Okay. Through euthanasia, that we should kill the person if the person is untreatable, if we know that person is not going to be recovered anytime. So we are actually punishing that person by making her to live into that state. Okay. So now when the euthanasia happen, euthanasia are of two types. One is something called as a active euthanasia and another is called as a passive euthanasia. In the active euthanasia, the brain is active. Okay. In active euthanasia, the brain is active. In the passive euthanasia, brain is dead. In the passive euthanasia, brain is dead. Okay. So let us suppose you are going for any operation. So in that case, doctor gives you euthanasia. So this is something called as a active euthanasia. You are aware of that your brain is in active condition, and then you are taking euthanasia for getting a pain relief. Okay. But let us suppose a person is in a coma whose brain is dead. In that case, euthanasia should be given. In that amount, the person will lose her or her life without any pain. Okay. So now for the passive euthanasia, that judgment became formed. So it was declared that for the passive euthanasia, if it has to be given, then 3 panel of doctors should be there who approve it, that person is in dead condition, brain is dead. 2 judge bench should be there, and third, relatives of patient should agree with this. Relatives of patient should agree with this process to kill the person through passive euthanasia if the person is in a brain dead condition. So law has not been framed. Still law has not been framed, but Supreme Court said Parliament can frame a law on the mercy killing, but they have to follow this consent. Whenever the law will be formed for the mercy killing, this process will be followed, where 3 panels of doctors will be required, 2 judge bench should be there, and relatives of the patient should agree for that. Okay. So then only this passive euthanasia will be allowed. Now within the article 21, there is article 21 clause A. It makes the right of education for the children of the age of 6 to 14 years a fundamental right. Okay. So see how this article 21 is spreading its wings. So from starting we are learning that article 21 deals with that person life, liberty, lived with dignity. So constitution provides that no person shall be deprived of his life or personal liberty, okay, except according to the procedure established by law. But now now as per the Supreme Court verdict, we are not following procedure established by law, we are following due process of law. But still within the article 21, the statement is procedure established by law. Okay. Now see how this meaning of life has been improvised, have been taken in the has been modified more, that within the article 20, let me zoom it more, article 21 A has been formed, which tells that the person have a right of education. Person have a right of education. For whom? For children of age 6 to 14 years, and that will be a fundamental right. Understood? So now right of education is also guaranteed for those children who are between age of 6 to 14 years. The state shall provide free and compulsory education to all the children of the age for the between the 6 to 14 years. So that's why we have a government schools and all, and nobody is deprived from going to that government school. Everybody is allowed to go to that government school, and that's why and government has to compulsory open the government schools, because Constitution guarantees the right of education for the children for the 6 to 14 years, and it should be free and compulsory. If the children is not if the children are unable to go to the private schools and all, so they have to take the education. Okay, this is compulsory for them. And if the child are unable to take private education, state government should have a right to education. Otherwise, anyone from the poverty line of the people, or the or below poverty line people, can go to the court, and they can clearly say that this government is not providing us the school for the children, for our children freely, and we are unable to afford the fees of the private schools. Yes, then there will be a action will be taken against the government. So there is a right to education. In Uni Krishna versus State of Andhra Pradesh, in Uni Krishna versus State of Andhra Pradesh case of 1993, Supreme Court had clearly recognized the fundamental right of every children for free and compulsory elementary education. Within this right, Supreme Court had clearly recognized that this right to education is a fundamental right. A right to education means like every children is a free and compulsory elementary education. As per the 86 Constitutional Amendment Act 2002, as per the 86 Constitutional Amendment Act 2002, this Article 45 came up with the amendment that previously it was education of children mentioned as a directive principle. It means not compulsory. Okay, it was not compulsory till 2002. In the Article 45, it was mentioned within the DPSP like education of children should be there as a directive principle, and and whatever the thing is mentioned under the DPSP, it does not made compulsory to a state. Okay, compulsory to a state, it just advice to the state. Okay, now then after 86 Constitutional Amendment 2002, it became a fundamental right, compulsory, and Article 45 became the state shall now the Article 45 then became the state shall make provision to provide early childhood care and free education to all children up to the age of up to the age of 6 years. Okay, to make this right to education effective. Okay, so the right of children to free and compulsory education 2009 was brought up, and we'll discuss this thing right to education for Article 45 in DPSP. Okay, currently I'm just giving a glimpse of it, because right to education is in Article 21 clause A, so that's why we are discussing it right now. So right of children to free and compulsory education 2009. What does this tell? That all the children in the age group of 6 to 14 shall be provided 8 years of elementary education. Where this education will be provided? In their neighborhood. Understood? This will be in their neighborhood. Now, no child shall be denied admission for want of any document. 0% of retention. Okay, no child should be deprived. No child should be no child should be denied admission for want of documents. So let us suppose tomorrow, even if you want to sit in a class and want to learn, no one can deny it. No one can deny from that you don't have a document, you have not taken admission. In that case, okay, no, it won't be denied. You can sit in the class, you can get education from it as per the requirement, as per the permission of the headmaster and all. But yes, no child can be denied on the basis of missing of any document. Okay, the child should be given education as per the right to education, free and compulsory education under 2009. The state have the responsibility of enrolling the children as well as their attendance and completion of 8 years of schooling. So now this becomes not a responsibility of parents. As per this point, 8 years compulsory and attendance maintenance, it is the responsibility of a state. That's why government do multiple advertisement that you should send your children to school regularly. Understood? And all private schools shall enroll children from weaker section of the society up to 25% of the enrollment. And it has been made compulsory that all the private schools should have a 25% children from a weaker section. Okay, now here I am telling that 0% retention. Where is that 0% of retention? It means that even if the children is failing, he can be promoted to the next level class. Okay, 0% retention. It can't be said that the child that is not being passed, and will tell that you are not being passed, you won't get education for the next class. So 0% retention policy is there within the India. It means that even, let us suppose you are in class 4 and you failed in the final exam of class 4, then also you are in the next year session, you will be allowed to sit in the 5th class. Okay, nobody can stop you from that. This is something called the zero retention policy. Even if the child is failing, he can be promoted to the next level. And the pace of learning varies considerably upon the social background of the children. That's why let us suppose children from a rich background where his parents is educated, and the children who are from a lower strata, their parents are not educated, they are not getting that type of environment. So there can be a difference in learning of the there can be a difference in the pace of learning from the different strata of the children. But at the end, both have to compete. Okay, so this was the explanation given, that the percent of retention that we should follow 0% retention. There are many times question has been raised on this policy, that why we are following 0% retention, 0% retention policy, why we are following. But the government has come up with the conclusion that there is a difference of pace in learning by the children, because the children who are coming and studying in this government school, they are mainly from the lower strata of the section, and that's why we should give them a promotion, a free promotion, even if they fail to do so, because their learning pace is different. That is the explanation given by the government in a period of time, in various whenever the question has been raised. And yes, there can be a multiple against of this percent of retention can be challenged for that, but currently this is the scenario. Percentage of retention, 0% retention policy we have. Okay, so we'll see article 22 in the next session. Okay, so till that, you please like and subscribe. This is a new channel, we really need your support. For any doubt, please connect with me on my social media handle, or please put a comment on this video. We'll look into that. Thank you.